We have a murder file. This is the murder file. And we have these white files because before us are minors. So when the court is faced with children, we must open up a file for a child in need of protection and care because they are all below 18. So the court will convert itself at some point into a children court. At that time, then I will ask everyone to leave the courtroom except the DPP and advocates representing the minor subjects. We're not going to call them accused persons. We do not have accused persons. These are children, so we shall refer to them and address them as subjects, minor subjects. If anyone reports that we have accused persons in court, you will have to face the music from this court. Also, the parents to the children, before me, you do not need to be shy. At some point, I'll want to see the faces of your children, and you're the ones who are going to help me identify them. For now, the children will remain masked for their own protection and safety in accordance with the Children Act. So, before we proceed, I have an opening statement to make, which I'm going to read. The court convenes today, the first day of July 2026, for the first formal mention of the matter of the Republic versus 8 subjects, each a child and each known throughout these proceedings only by an anonymized designation. I acknowledge the presence of learned counsel for the prosecution and the defense, the children's officers, probation officers, parents, and guardians of the children, accredited members of the media, and all the persons lawfully present before this court. I also acknowledge with gravity those whose presence is not visible within this courtroom, yet whose grief accompanies every stage of the proceedings. The families of the 16 young girls who lost their lives during the tragic events of 28th of May 2026. Their loss is immeasurable, and this court recognizes the profound pain they continue to endure. This court is seized of a matter that has profoundly touched this nation. 16 children are dead. Dozens more bear injuries of the body and of the mind that may not heal fully within a lifetime. A school that stood as a place of learning and inspiration was in a single night transformed into a scene of national grief. The nation mourns. The nation seeks answers. The nation expects justice. Yet, justice cannot be administered through public outrage, nor can it be determined by social media commentary, public opinion, or the intensity of national emotion. The Constitution of Kenya requires this court to decide this case only upon admissible evidence and the applicable law, nothing more, nothing less. The subjects before this court face the most serious criminal charge known to our law. They are also children. Neither fact diminishes the other. The seriousness of the allegations does not diminish their constitutional rights. Equally, their status as children does not diminish the gravity of the lives that were lost. The duty of this court is to hold these two realities in careful balance throughout these proceedings. To forget either would be to fail the victims, to fail the subjects, or to fail both. This court will not do that. Because these proceedings involve subject minors and have generated exceptional national interest, the court considers it necessary at the earliest opportunity to establish a comprehensive framework governing the future conduct of this trial. Accordingly, the court shall now deliver case management directions to the media, reporting guidelines designed to safeguard the constitutional rights of every participant, preserve the integrity of the judicial process, protect vulnerable persons, facilitate responsible public reporting, and maintain public confidence in the administration of justice. The court emphasizes that these guidelines are not intended to shield proceedings from legitimate public scrutiny. Rather, they are intended to ensure that justice is administered according to law, fairly, transparently, and without prejudice. The court shall now proceed to deliver as follows. Case management directions and media reporting guidelines. This matter was transferred from the High Court at Naivasha to this court for administrative and security reasons. The transfer was effected solely to facilitate the safe, orderly, and impartial administration of justice. It neither reflects nor suggests any opinion by court regarding the guilt or innocence of any accused person. The sole responsibility of this court is to ensure that these proceedings are conducted fairly, efficiently, and strictly in accordance with the Constitution and the law. Given the exceptional public interest generated by these proceedings and recognizing that they involve subject minors, this court considers it necessary to establish at the outset a comprehensive framework governing case management, courtroom conduct, media reporting, witness protection, and the welfare of the subject minors. These directions are issued pursuant to the court's constitutional mandate to ensure the fair administration of justice and shall remain binding throughout these proceedings unless varied by further order. Legal framework. This is not an ordinary criminal trial. It concerns minors who are children and is therefore governed not only by the substantive provisions of the Penal Code, but also by the Constitution of Kenya, the Children Act 2022, Kenya's international obligations, and the established principles of child justice. The court is bound to apply this framework throughout these proceedings. At the international level, Kenya is a state party to the United Nations Convention on the Rights of the Child and the African Charter on the Rights and Welfare of the Child. By virtue of Articles 2, 5, and 6 of the Constitution, the general rules of international law and treaties ratified by Kenya form part of the law of Kenya. These instruments require that the best interests of the child be a primary consideration in every matter concerning a child, that the primacy and dignity of children be protected throughout legal proceedings, that detention be imposed only as a measure of last resort and for the shortest appropriate period, and that child justice systems prioritize rehabilitation, reintegration, and the child's constructive role in society. The court is further guided by the United Nations Standard Minimum Rules for the administration of juvenile justice, that is the Beijing Rules, which require juvenile justice to promote the child's welfare, safeguard due process and fair trial guarantees, protect the privacy of child offenders, ensure proportionality in decision-making, restrict deprivation of liberty to exceptional cases, and promote rehabilitation and successful reintegration. Likewise, the United Nations Committee on the Rights of the Child, in General Comment number 24 of 2019, on children's rights in the child justice system, affirms that the principal objectives of child justice are rehabilitative and reintegration, and that children in conflict with the law must be treated in a manner consistent with their dignity, age, and development needs. Regionally, Articles 4 and 17 of the African Charter on the Rights and Welfare of the Child reinforce these principles by requiring that the best interests of the child remain the primary consideration in all actions concerning children, and that children in conflict with the law be treated in a manner consistent with their dignity, age, and worth. The Charter similarly emphasizes privacy, rehabilitation, and reintegration. The constitutional framework is equally clear. Articles 53(2) provides that a child's best interests are of paramount importance in every matter concerning the child. Article 50 guarantees every accused person the non-derogable right to a fair trial. Article 28 and 31 protect the dignity and privacy of all persons, including the minor children before me, victims, and witnesses. Articles 33 and 4 guarantee freedom of expression and media freedom, subject to respect for the rights and reputations of others and the proper administration of justice. Articles 10, 48, 159, and 165 further require this court to uphold the rule of law, ensure access to justice, administer justice fairly and expeditiously, and exercise its judicial authority independently. The court must therefore balance the rights and interests of the children in conflict with the law, victims, witnesses, the media, and the public, while preserving the integrity of the trial. The Children Act, on the other hand, number 29 of 2022, provides the primary statutory framework governing proceedings involving children in conflict with the law. Section 8 codifies the constitutional principle that the best interests of the child are the primary consideration in every matter concerning a child. Sections 11 and 244 safeguard the child's dignity, privacy, and identity, while Part 15 establishes a child justice system founded on diversion, rehabilitation, reintegration, and detention only as a measure of last resort. The Act further prescribes child-sensitive procedures, including social inquiry reports, parental or guardian participation where appropriate, and the determination of age and criminal responsibility where necessary. These provisions inform every procedural decision made by this court. The court is equally required to safeguard the rights of victims. Section 4, 9, 10, 12, and 13 of the Victim Protection Act 2014 require courts to protect victims' dignity and privacy, facilitate their participation where appropriate, and shield them from intimidation and secondary victimization. These protections complement rather than diminish the accused's constitutional right to a fair trial. Finally, the subject minor stand charged with the offense of murder contrary to Section 203 as read with Section 204 of the Penal Code. While the Penal Code provides the substantive criminal law governing the charge, it must be applied in harmony with the Constitution, the Children Act, and Kenya's international obligations governing children in conflict with the law. Depending on the evidence ultimately adduced, the provisions relating to manslaughter under Section 202 of the Penal Code may also fall for consideration where the prosecution proves an unlawful killing but fails to establish malice aforethought. Accordingly, these proceedings shall be conducted within the comprehensive constitutional, statutory, and international framework governing child justice.